Good morning once again. My name is Barbara Gressel. I am an attorney with the Department of Business Affairs and Consumer Protection, and I am also the Deputy Commissioner of the Prosecution and Adjudication Division. Our department is the department for the city that licenses and regulates businesses. I've been working for the city for over 19 years. For 10 of those years, I was a prosecutor. I'd like to thank the people who have joined me in this panel today to discuss the Chicago minimum wage and paid sick leave ordinance. I'm going to tell you a little bit about my colleagues today. Starting at the left, for over 11 years, Adam Cater has served as Worker Center Director for Arise Chicago, where he coordinates low-wage worker education, organizing, and policy advocacy. Previously, Adam worked in community-based adult education. He holds a master's degree in urban planning and public policy. Wendy Pollack is the director of the Women's Law and Policy Initiative at the Sargent Shriver National Center on Poverty Law. Under Wendy's direction, the WLPI draws on the experiences of women and girls and brings those experiences to the forefront in the Shriver Center's analysis of poverty and the development of solutions to end poverty permanently. Wendy has worked extensively on employment, education, and training, violence against women and girls, and other issues affecting low-income people on the local, state, and federal level. Melissa Josephs is Director of Equal Opportunity Policy and has been a member of the Women Employed Staff since 1990. She has expertise in a range of workplace issues such as paid sick time, sexual harassment, fair wages, work and family, and affirmative action. And she promotes passage and effective implementation of equal employment opportunity laws and regulations at the local, state, and federal levels. Prior to joining Women Employed, Josephs was a community organizer at the Northwest Neighborhood Federation. Melissa has a BA in English and Journalism from the University of Wisconsin-Madison and a JD from IIT Chicago-Kent College of Law. And last but not least, Ray Phillips is a senior counsel with the city's law department who litigated for 10 years, including matters originally handled by Department of Business Affairs and Consumer Protection. He currently works in the Division of Legal Counsel, writing ordinances and providing legal advice to departments, the mayor's office, and aldermen, and also to me. I call these people my friends, and I am so grateful that they have agreed to be here today for this discussion and to help answer any questions we may have. Before I begin, I want to urge those of you who are interested to pick up the information that we have out on the table at the entry to this room and also out in the lobby area. I'd like to ask you to hold your questions until the very end. I have about a 10-minute PowerPoint about the ordinance, and then we'll all be speaking. And after that, I'd like you to save your questions, if you will. So let's talk about Chicago's minimum wage and paid sick leave ordinance. I think maybe we can turn off the lights and see better. Can everyone see that? So, the first question, to whom does the minimum wage and paid sick leave ordinance apply? So it applies to employers who maintain a business facility within the city of Chicago and or are required to obtain a business license thank you, to operate in the city. The ordinance applies to employees who work at least 2 hours in the city within a period of 2 weeks. And this also includes domestic employees and home health care workers. A union may waive its members' rights to collect the minimum wage or to paid sick leave as part of a collective bargaining agreement. What is the minimum wage currently in Chicago?
$13.
As you know, Chicago began to raise the minimum wage in stages on July 1st, 2015. The current minimum wage is $12 as of July 1 of this year for non-tipped workers. The minimum wage for tipped employees is now $6.25 per hour. And the minimum wage is set to be raised again next year on July 1st to $13. Who qualifies for paid sick leave? Again, employees who work more than 80 hours in any 3-month period in the city of Chicago, employees who work at least 2 hours within any 2-week period in the city of Chicago, and employees whose employer maintains a business facility in Chicago or is subject to one or more of the city's license requirements. So what do I mean by this last bullet point? There are businesses that may not be located in the city. Please come on in and take a seat. There may be businesses that are not located in the city, but who actually are required to obtain a city license because they perform services in the city. An example of that might be a home repair contractor or a caterer who comes in and performs services in the city. They may be located in Harvey or in Evanston, but they're really servicing customers in the city of Chicago. Those businesses then would be required to have a special City of Chicago licenses that allows them to perform those services. The ordinance does not apply to employees who work less than 80 hours per calendar year in Chicago, government workers other than City of Chicago, independent contractors who don't meet the definition of an employee under the Illinois state law, and participants in a work experience program. And importantly, domestic workers are covered by the minimum wage and paid sick leave ordinance. What is a domestic worker? The ordinance is very clear, and I've copied the whole definition here on this slide. Domestic worker is defined by the ordinance as a person whose primary duties include housekeeping, house cleaning, home management, nanny services, caregiving, personal care or home health care services, home health services for elderly persons or persons with illnesses, injuries, or disabilities who require assistance in caring for themselves, laundering, cooking, companion services, chauffeuring, and other household services to members of households or their guests in or about a private home or residence or any location where the domestic work is performed. So under the paid sick leave ordinance, employers have 3 obligations. There are 3 main categories, and that is the accrual, earning, or grant of hours, paid sick leave hours is number 1, carryover of paid sick leave from one year to the next, and the usage of paid sick leave. Now let me just remind you that the ordinance establishes minimum standards, and of course employers may meet or exceed these requirements. How does paid sick leave accrue? This is a question we've been asked many, many times. Employees began to earn or accrue paid sick leave hours on July 1st last year, 2017, or on their first date of employment, whichever was later. Employees earn or accrue paid sick leave at the rate of 1 paid hour for every 40 hours worked. And the ordinance requires a maximum of 40 hours of paid sick leave per calendar year. Of course, an employer may set a higher limit. Paid sick leave accrues only in hourly increments, and employers must give employees up to 40 hours of paid sick leave every year. An employer must allow an employee to use paid sick leave no later than on the 180th day following the commencement of his employment. For purposes of last year, when the paid sick leave ordinance went into effect, that meant that on December 23rd, something like that, 22nd or 23rd, an employee could begin to use the hours he or she had begun to earn. Now, employers also have an option. The rules allow an employer to immediately grant paid sick leave for their employees instead of using an accrual method. If it's easier, absolutely, an employer may grant their employees that 40 hours of paid sick leave at the beginning of a year. If paid sick leave is immediately granted on the date of eligibility, employees must be provided 40 hours within the first calendar year. And if the employer is subject to FMLA, Family Medical Leave Act, a federal act, another 20 hours for FMLA purposes each subsequent year. What is carryover? At the end of a covered employee's 12-month earning period, the employer must allow an employee to carry over half of any unused earned paid sick leave, up to a maximum of 20 hours. If an employer is subject to that Family Medical Leave Act, covered employees may also carry over up to 40 hours of unused paid sick time to be used exclusively for FMLA eligible purposes. An employer who grants 40 hours of paid sick leave at the beginning of the year does not need to carry over any time unless the employer is subject to FMLA. What is the FMLA Act, and what are the requirements under this act? The Family Medical Leave Act applies only to certain employers. These employers may be a private sector employer, a public agency, or a school. For example, the City of Chicago is an FMLA organization. A private sector employee is covered by the FMLA if it employs 50 or more employees in 20 or more work weeks in the current or previous calendar year. So it applies then, as you can see, to larger businesses. A covered employee who works for an employer that is subject to the FMLA may carry over up to 40 hours of accrued and unused paid sick leave to be able to use exclusively for FMLA purposes, in addition to the maximum of 20 carryover hours allowed for regular paid sick leave purposes. And here's the third obligation. When can paid sick leave be used? An employee may use paid sick leave when that employee is ill or injured or for receiving medical care. An employee may use paid sick leave when a family member is ill or injured or to take care of that injured person, sick person. Paid sick leave may also be used if an employee or a family member is the victim of domestic violence or a sex offense. Paid sick leave may be used when an employee's business is closed by order of a public official due to a public health emergency, or the employee has to care for a child whose school or place of care has been closed due to a public health emergency, like the bird flu, or sometimes schools close down because of illness. It's important to remember that an employer may not require that a covered employee find a replacement worker to cover those hours they'll be gone. And an employee may use up to 40 hours of paid sick leave per year, or up to 60 hours in a FMLA covered workplace. So employers have to keep a lot of records for their covered employees, and for 5 years they have to maintain these records, and the department does subpoena these records when we have a complaint, and we may review these records when we have a complaint against a business. And the ordinance, which is printed out and available for you to take, details what those records are. Now, employees have certain rights under the ordinance. If they believe they have not been granted paid the minimum wage, or not been granted paid sick leave, they're entitled to call 311 and file a complaint with the City of Chicago. A complaint form is then forwarded, an affidavit, and the department will investigate this case. Just briefly, I'll talk about the complaints that we've received. Since the minimum wage went into effect in July of 2015, we've received over 400 complaints, and the department has recouped over $300,000 in back pay for over 400 employees. We have, for the first 2 years, we did not enforce the ordinance in terms of issuing citations for violations. We felt it was important to educate businesses on how to comply with the ordinance. So most of the $300,000 that we recouped in back pay was by agreement. Beginning last year, we began to cite businesses. We've taken 3 businesses to court and gotten back pay for those individuals in addition to fines. And we've fined 3 businesses over $120,000. So depending on the numbers of employees that were shortchanged and the amount of time that people were shortchanged. We had one business that was found to have underpaid 168 employees for 3 years. So again, our goal is not enforcement per se, it's compliance by businesses. So how exactly can businesses comply with the ordinance? Well, the first thing is that businesses need to post notices of the paid sick leave and minimum wage in their businesses. These have to be posted in conspicuous locations. Also, when an employee first begins to work for the business, you must provide these notices in their first paycheck. So the department is enforcing that provision of the ordinance, and in the last year we've cited 28 businesses with failing to comply with the notice requirements and have collected $10,500 in fines. So it's a per day fine, but we don't ask for a per day fine. We just say post it and here's the minimum fine once you prove that it's posted. So again, the first thing a business can do to comply with the ordinance is post the notice. Secondly, employers must maintain records and make those records available to the department. Employers may set a reasonable minimum for requested time off, not to be more than 4 hours per day. So, for example, if an employee comes to an employer and says, I have a doctor's appointment and I need to take time off, the employer can say, sure, you can take 3 hours off, or no more than 4 hours. Employers may require notice before paid sick leave is taken for foreseeable uses, such as a doctor's appointment, or as soon as practicable on the day of leave. You know, if I have a car accident on the way to work, I'm not going to be able to call in immediately. I can call in later, but that's understandable. Employers may require documentation for the use of paid sick leave only if an employee is absent for more than 3 consecutive work days. And finally, employers may not discriminate or take any adverse action against any employee in retaliation for exercising his or her rights. The ordinance also provides a private right of action to employees. So instead of filing a complaint with the city, an employee or a group of employees can file their own action in circuit court. So that's my presentation. And instead of responding to questions right away, I'm going to ask my distinguished panel, who have prepared some remarks, to go at it.
Good morning. So again, I'm Wendy Pollack. I'm with the Sargent Shriver National Center on Poverty Law. And I was asked today to talk a little bit about the how the minimum wage ordinance kind of came to be, and so I'll do that because my agency was very much involved in this. I'm sure many of you are aware of the worker protests and movement to gain higher minimum wage. Some of it's called Fight for 15, that sort of thing. So advocates were very active in the city around the time that all this was happening. So in response, the mayor in 2014 decided to form a working group of a minimum wage working group that was made up of representatives of business, aldermen, obviously, advocate groups like ourselves, and in representatives of businesses were people like from the Chicagoland Chamber, from Restaurant Association, from retail merchants, that sort of thing. And he asked, and my boss, the head of my agency, John Bowman, was a co-chair, so I was very involved. I wasn't an official member of the task force, but he was co-chair of the task force. So, the purpose was to look into the issue and try to come up with recommendations for a city ordinance on minimum wage. And they spent several months looking at this, lots of research. There was several, maybe 5 public hearings around the city where workers and businesses were able to speak out. And they relied a lot on experts and research and did a very thorough job. And the consensus was to phase in a $13 minimum wage over the report, which actually you could find online, the city. It's called A Fair Deal for Chicago's Working Families. So this is from 2014. To phase in a $13 an hour minimum wage over 4 years. What ended up in the ordinance was actually over 5 years, so they spread it out a little more. And we knew that, and the ordinance kind of looked at, the state law, which has lots of exemptions. So, one of the big exemptions that affects particularly very small employers is that the state minimum wage is the businesses with less than 4 employees are exempt from the state minimum wage. So that's true also for the city minimum wage, except for the domestic worker issue, and I could address that more later if there's questions about that. So this, the study shows, this report shows that they expected the impact to be on 410,000 Chicagoans that their wages would be lifted up. And that's over 30% of the Chicago workforce. And a disproportionate number of these workers are women and people of color. So there was an acknowledgement that $13 an hour is not a living wage, but it is a minimum wage. And quite frankly, to just even, I'm sure it's higher now, but just to rent a 2-bedroom apartment in the city of Chicago on fair market value, you need at least $19 an hour. So, again, it's a minimum wage, not a living wage. So the working group also addressed the sub-minimum wages that are part of the state law, sub-minimum wages for teens and for tip workers. And the one they decided to address was on tip workers. And what they did is basically add the first year 50 cents more. Now, the tip minimum wage under state law is 60% of the state minimum wage. So for tip workers right now, it's $4.95 an hour. So what the city ordinance did was add 50 cents an hour for tip workers the first year, and then $1 an hour, and now it's indexed to the cost of living. And as Barb said, right now the Chicago tip minimum wage is $6.25 an hour because of the indexing. The need for the minimum wage was raising it was really great. Action wasn't being taken on the state level, although all of us are trying to make that happen on the state level. So it's not like there's not advocacy there to make it fairer on the state level. As I said, the state minimum wage is right now $8.25 an hour. But the Chicago area, our cost of living here is probably 20% or more higher than the rest of the state. It's just a higher place, more costly place to live. So the prediction was that this wouldn't have a negative net impact on businesses in Chicago. And we're not saying that it won't have a negative impact on particular employers or particular employees, but overall the impact they felt would be, there really wouldn't be a huge impact. And there was a study that was just released in June for the study by the University of Illinois to talk about the first 2 years of the impact of the Chicago minimum wage, and this bears this out. Of course, it increased workers' wages by an average of 2.5% increase in incomes for Chicago workers, but it showed no real net impact on negative impact on the growth of private business establishments in the city. It also resulted in higher consumer demand, which of course could help businesses in the city. So again, this grew out of the importance of raising low-wage workers' raises. The average worker, people keep talking about the minimum wage as if the average worker are teenagers, but actually the average age in Chicago is 33 years old. Who are getting the minimum wage. So this has really had a positive impact on the city, and the federal minimum wage for a 2-person household is about $16,500 a year, and the state minimum wage of $8.25 wouldn't even get you out of poverty, even for someone working full-time year-round. So that's the reasons behind it, and I'll take your questions at the end if you have any. Thank you.
Good morning, everyone. Again, my name is Adam Cater, and I work for Arise Chicago. We're an interfaith workers' rights organization, and we represent many low-wage workers who work across many different industries. And I should first thank Barbara and the Business Affairs and Consumer Protection for inviting our agency to be with you this morning. I also wanted to thank you for attending, for coming to learn about the ordinances and to have a conversation. I just wanted to briefly talk a little bit more about, from our standpoint as advocates who were involved in the coalition to help pass paid sick days, why this ordinance is so important. I think, anecdotally, our organization knew from learning from over 20 years of speaking with workers that a lack of paid sick days was a very, very widespread problem. And we surveyed our members and found that actually none of our members had access to that policy. And we looked into some of the research and confirmed, not just anecdotally, but statistically, how widespread of an issue this was. Minimum wage earners, who we were just talking about, were the least likely to have access to sick days. Close to 80% of food service workers did not have access to sick days. And overall, looking at the entire workforce in Chicago, we found that 42% of all workers didn't have access to sick days. So this really confirmed what we had been seeing and experiencing and hearing from people who were really struggling even though they were working. And I think it's obvious to say, but perhaps it's worth saying, we all get sick. Everybody gets sick sometimes. And that shouldn't get in the way of our ability to earn a living. That this is a natural thing that we all face, and if we're willing to work, if we're able to work, it should not get in the way of that. Our belief is that to care for oneself and one's family shouldn't be sort of a luxury, but it should be a universal workplace policy. So that's why we really applauded this ordinance. I think the importance of this policy can't be overstated. This comes from hearing stories from people who were in difficult situations. I think of one member with a special needs child who said he would agonize when there was a recommended treatment or appointment for his child, and he had to decide whether he could afford to leave work or not to care for him. That was a real question that he dealt with on a regular basis. And I think of another one of our members who had a similar situation where when her husband had surgery and needed somebody to pick him up from the hospital, she was the one that really needed to be the one to pick him up and care for him that day, but was told that she had to choose between her job if she were going to take a day off. So with situations like that made it so pressing for us to really make sure that there was some kind of baseline standard, sort of like what Wendy was saying about the minimum wage, recognizing that it's not necessarily a living wage. Again, we're talking about just doing a floor or a baseline policy to kind of bring up all workplaces at once. Besides this obviously benefiting workers, we think that it really has a cumulative effect on community. Given how such a large percentage of the workforce now is under protection from these ordinances, we can expect to see a higher degree of stability across many households. And I think down the line we can expect to have more benefits. We also, having spoken to many businesses over the years, one thing that we heard a lot from business owners was that if businesses that already offered this kind of a policy felt like it was tough competition with other businesses that weren't offering it. And so, some said, oh, we used to offer that, but then, we found out others weren't, so we didn't. And we kind of wanted to eliminate any scenario for that for a lot of businesses that, wanted to provide the policy, but felt like it was hard to. So I think that this ordinance also addresses that question of kind of leveling the playing field so that everybody's competing on an even field. And then finally, though I certainly am not a business owner, but I think as a consumer of businesses, I see this as having a benefit for the public's health, particularly thinking about any business that interacts with the public in a close way, retail, restaurants, other personal services, that this is a way to make sure that people are not going to work sick and infecting the public. This is an opportunity for them to really stay home and take care of themselves so that the rest of us don't get sick. And for any of you who own businesses that interact with the public, I'm sure that you would agree that your public reputation, is very valuable, and that one problem you don't want to deal with is if you're known as a business where, with food poisoning or, with other things like that. So I think that from that standpoint, we think this is also a benefit. So that's just a little bit more about why we support this ordinance and why we think it's been a benefit for many people here. So thanks, and I'm happy to answer any questions if you have some at the end.
Okay, so I'm just going to finish up talking about a little bit more about sick time and embracing some of what Wendy and Adam said. So one question we get a lot, I don't know who's in the audience, if you're business owners or workers, but oftentimes from businesses we get the question, why do we need a law for this. You know, like as Adam is saying, sometimes employers are doing the right thing. And I think similar to why we need something like a minimum wage law, if there was no minimum, you know, I think a lot of employers, you know, would be offering like mere pennies to workers. You know, I think smart, high-road employers know they have to pay reasonable wage to get good workers and, you know, loyalty and, you know, keep workers and, you know, good production. But so in the same ways, people know we needed child labor laws so that employers didn't abuse children, or occupational safety and health laws. And so, again, I think a few people have said this, but this sick time law, just like minimum wage, was just a minimum standard. So employers can, you know, go above that. So a lot of employers over the years, instead of offering benefits separate like vacation and sick, have just put it all under PTO, paid time off. And usually that's a few weeks. And as Barb said, paid sick time is only 5 sick days or 40 hours a year. So any employer that was already offering or is already offering paid time off doesn't have to offer an additional 5 sick days. Because PTO can be for anything, right? You don't even ask the person. They could be staying home waiting for the cable guy, right? It just doesn't really matter. But the one thing that we did the city passed in the sick time ordinance for sick time was to say you can't require an employee to give you notice if they don't have it. If they know they're going to be in the hospital, yeah, there can be a reasonable amount of notice given. But as I think a lot of people know, you get sick or your kid gets sick. And we had heard that a lot of employers that had PTO policies would require notice, and if they didn't get it, there'd be discipline. Or some policies just checked off like a disciplinary mark every time people used sick time or any of their vacation, any of their PTO, so that discouraged people from using it. So we definitely didn't want that to happen. We wanted people to use this because, you know, again, as Adam is saying, it's good for business. Businesses don't want their workers coming into work sick. They're not as productive. They don't want them infecting their coworkers, and even more, they don't want their workers infecting the public. As a little bit of background, Women Employed is part of a coalition with Shriver and Arise and just a huge other number of coalition members who had put an ordinance together with aldermen that was introduced in the city in 2014. And that ordinance is a little different than the ordinance that passed in terms when we introduced it. The ordinance talked about different amount of time off depending on the size of the employer. Now it's regardless, everybody minimum 5 sick days or 40 hours. And the ordinance we had introduced, you were able to earn it a little quicker, and in terms of the eligibility, it was a little bit quicker. But similar to what happened with the minimum wage, when we introduced the ordinance in 2014, the mayor was generally supportive but wanted to do a task force. And so all of our groups were on that task force in addition to business lobbyists and individual businesses and a lot of elected officials, a lot of aldermen and academics. And they actually looked at this and a couple of other issues, but part of this task force that met in 2015 held focus groups throughout the city. And there were a few that were specifically for employees to attend and a few for employers. And you know, we learned a lot of the issues that Adam is talking about, hearing the problems from workers. And frankly, we heard from businesses as well. Some employers were saying maybe they were currently offering it for certain workers, maybe salaried workers, but not hourly, or maybe full-time, but not part-time. So we took all this in, and a lot of negotiation that went on, and that task force issued a report in 2016 with recommendations, which eventually led to this ordinance that was introduced in 2016 and passed, that you have a copy of, and that it went into effect a year later in 2017. I think we're all curious to hear either questions you have or feedback or comments. Barb, I just want to make one comment. There's one little typo on your PowerPoint on, I don't know what the page is, but when it talks about qualifies for sick days, employees who work 80 hours, it's actually in a 4-month period, not a 3-month period.
Okay.
And the only reason I know this is because one of the questions we get from people. They'll say, I have a babysitter. Am I going to have to give sick time to a babysitter? And what I say, I use this statistic all the time, because what I say is, okay, 80 hours over 4 months, that's like 20 hours a month, each month, or 5 hours a week. If you have a babysitter every week and you pay that babysitter, at least, you're for 5 hours, they're going to be able to accrue some sick time. But it's going to take a long time. Like the notes for the babysitter, they average 5 hours a week. It would take them, it's over 4 months.
Yes,
And you wrote 3 months.
you're correct.
Yeah, okay. I'm just telling everybody, so I don't know what page it's on, but just, So anyhow, if you have this
Well,
babysitter.
I'm looking where in the ordinance, under paid sick leave, how it's earned. So, yeah.
Okay, so yeah, this babysitter thing, yes, if you have a babysitter and you pay them at least 5 hours every week, it's going to take them 8 months to earn 4 hours. And as Barb pointed out, that's the minimum. You can't make anybody earn use a full day, but you can require them to wait until they've earned at least 4 hours. So yeah, if you have a babysitter, it's very possible you might have to pay them for a half of a sick day a year. But the answer is yes. Okay. Done.
All right, well, I want to thank everyone. And actually, Ray is going to call on people and answer questions. Okay.
All right.
Okay.
In the back.
Let's say you're a full employee, you're not full-time, you're not part-time, but then you manage to get the opportunity to work, say, maybe 72 hours. Does that employer have to pay you overtime pay for that time, meaning 40 hours is regular work hours? And then the other 32 hours, would be considered time and a half, or is just, they can pay you just for the 72 hours?
So the question, for those who couldn't hear, is about floater employees who may, and correct me if I'm misstating the question, in, say, a work week may end up working 72 hours, certainly over the 40 hours, and whether that employer needs to pay the employee overtime wages. That would be, and before I answer the question, let me just say, as an attorney for the city of Chicago, I can't give any of you legal advice. I cannot, I'm not going to be saying anything that that isn't specific, but in general. And the answer to your question would be found in the Illinois minimum wage law, which, if I remember correctly, sets a work week at 40 hours. And so if in a 7-day period an employee is working more than 40 hours, that employee has to be paid the appropriate overtime wage. So, yes.
However, let me just tack on that the city does not enforce state law. So if there would be a problem with overtime and not being paid overtime, the workers' relief would come either from the state or labor, the Illinois Department of Labor, or the federal Department of Labor, which handles overtime issues.
Will there be a statute of limitations on that?
The question is there a statute of
In
limitations?
other words, if this person worked 72 hours and it was 3 months ago, 4 months ago.
You know,
It's
that's...
at least 3 years.
3 years?
At least. Might be longer.
Yes, sir.
I'm curious, when you were talking about babysitters, who are typically not W-2 employees, so would this also apply to, for example, Uber drivers or every employee in Chicago?
The question is whether these ordinances apply to Uber drivers, and in general, one of the exceptions is independent contractors. So
But wouldn't a babysitter be an independent contractor?
that
Okay, the question is, wouldn't a babysitter be considered an independent contractor?
That would be that's not a question that I've come across previous.
Only because you were talking about using the babysitters as an example.
Right.
So that's what,
I think that a distinguishing characteristic there is that a babysitter may fall under the domestic worker
all right.
provision.
You know, a full time.
So some may be independent contractors and some may not.
Okay.
I mean, you know, it depends on how that worker presents themselves, if they, you know, and who has control of their hours and things
I
like that.
understand.
So, and let me just weigh in on this babysitter issue. The ordinance clearly defines child care as being a domestic worker. And I think what the ordinance anticipates is a private relationship between you and, between the employer, the parent or the family, and a caregiver. However, there are times when a parent or a family may hire someone through an agency, and that would change the relationship, because then that caregiver is paid through the agency. Okay.
And if I could just add, in general, since these are laws about employment, you have to be a worker to be covered by it. So if you're an independent contractor, you're exempt from laws that deal with workers. So if, you know, for an Uber driver, you know, you're not considered under current law a worker for Uber employees, my understanding.
Well, if I could jump
Yeah.
into
In
that
our law.
one too,
Yeah.
it depends what state you're in.
Yes, right.
So,
Speaking of
so it's the Uber driver, the issue with an Uber driver really varies from jurisdiction to jurisdiction. So in California, for example, there's been a decision that says an Uber driver, and we're just saying Uber, what we mean is a transportation network provider, because there are different companies, but that those drivers are in fact employees. That is not currently the law in Illinois. So one of the difficulties we have, and we want to be very careful, as Ray has said, is the intersection of this ordinance with state and federal law. So we are not, Ray and I, even though we're attorneys for the city, are not experts in the state or federal law. We have knowledge because of our enforcement and knowledge of this ordinance, but we may circle your question exactly rather than answer it. So I apologize.
In the very back.
I didn't quite understand when you were talking about if an employee requests off for a doctor's appointment, and you said a minimum number of hours can be set, no less than or maximum. I'm not sure on the wording. I read it a couple times, and your explanation didn't really clarify for me.
Okay, so the question is, there was a slide that talked about that an employer may set a minimum or maximum number of hours that an employee could take off, and the ordinance addresses this by saying that the employer may not require more than a 4-hour
As a minimum.
as a minimum. So what that means is that an employer may say, it's not legal, according to the ordinance, for an employer to say, you can't take off only 4 hours for your doctor's appointment. You have to take off the whole day. You have to take all your pay, 8 hours. The employer can't say that. The employer may only require the minimum of 4 hours, a half a day.
Okay.
And some employers wouldn't require anything. They might say, oh, just go home an hour early or something. But some employers might want to set a floor for their employees. And the ordinance says you cannot set more than 4 hours as the floor. Does that make it more Understandable?
Thank you.
Okay.
In green, I believe.
My question is, I have a business in Chicago, I'm licensed in Chicago, I reside, my office is in Chicago, but I have employees that are from Cook County, but outside the city limit. And also, some of my employees from Chicago service people outside Chicago, outside the city limit. Now, what do I pay them? Because everybody right now is at $12, but my starting pay is $11 an hour, so.
What-
Do you understand?
Yes. So the question is whether you're obligated to pay the workers who may not even be working inside the city of Chicago, the Chicago minimum wage. Sorry?
Or even the one that I have some that do not reside in Chicago.
Right. The location where a person resides, it doesn't affect what their pay is with regard to this ordinance. An employer is one who, correct me if I'm wrong, is one who is licensed in the city of Chicago and does business in the city of Chicago. A covered employee is one who doesn't meet one of the exceptions and works for an employee. Are there any other?
No, so, the employees that work in the city of Chicago, regardless of where their homes are, if they're working in the city of Chicago, they are paid the hours that they work in Chicago, the Chicago minimum wage. If you have employees that work in Cook County, then they need to be paid the Cook County minimum wage, which right now isn't the same, I believe, but
Right.
it will catch up,
Well,
apparently.
the Cook County followed the city and passed a very similar ordinance, but many of the suburbs have opted out. And so, you should check. I mean, I think there's only like about a dozen suburbs that are, are there 19 now? And they're also behind, they're not at 12. I believe this is like sort of the second year for them, and they may have started at 10:50 and now they're at 11. And then they'll go to 12 and then 13. And that law does, the Cook County law does say it's where the worker is working, not where the employer is. So, do you know offhand what suburbs your workers are working?
Maybe suburb on the southwest and west of Chicago, you know.
Yeah, if you want, we have a list on our website of each suburb that's in Cook County. So if you go to Arise, ARISE, Chicago.org, and if you go under we have a public policy section that has the Cook County ordinance, and it has a complete list of the suburbs that have a higher minimum wage.
You said IRSIE?
I'm sorry, that's ARISE, Chicago.org. And also afterwards, if you like, I can give you my card with the website on it.
Only when they're working in Chicago?
Can you
And so, and I'm going to make one thing slightly clear because I was not clear when I said it. The Chicago minimum wage ordinance only applies to those employees who are working while physically present within the borders of the city of Chicago.
So then it doesn't apply if I have an employee who's from Shamrock, for example, she works and she works in Shamrock for me, then she doesn't have to be paid $12 an hour, is that right?
That's correct. Again, the question is, if I have an employee that lives outside of Chicago and works outside of Chicago, even though I'm a Chicago licensed business, do I have to pay her the Chicago minimum wage? And the answer is no. The Chicago minimum wage is paid to workers who work within the geographic confines of the city.
Now, if I have a Shamrock employee who works for someone, works for me in Chicago, then I have to pay her
If the question is, if my worker who lives outside of the city works in Chicago, do I have to pay the minimum wage for Chicago? And the answer is yes.
Gentleman in the back.
So, does it matter whether or not the people are doing the same type of work? It seems to me that you would open yourself up to all kinds of liability in terms of discrimination, in terms of pay and wages. I mean, that, intuitively, that just doesn't sound like a good practice, a good business practice. And I'm in the service industry, so I'm very dependent on my employees in terms of, goodwill and image and doing the work correctly. I would not want people in one location, and I have people throughout the county too. I would not want people in the city, bragging to people that are working in the suburbs. I mean, that could be a nightmare for me because I install blind shades, and so it's like, I'm just showing now. Put this thing up crooked or upside down. I mean, people do that kind of stuff, and I would just not want that kind of ill will or open myself up for the liability of somebody suing me. So, for a couple of dollars, I think this would be worth it to me.
So to recap, if a business has employees in multiple zones, say in Carbondale, in Schaumburg, in Gary, and in Chicago, that may mean that there are multiple minimum wages that business is subject to. And it is an interesting policy decision as to how the business is going to resolve that, whether pay all of the employees the same or to pay the minimum wage. And
The Chicago minimum wage.
as employers, all employers have the joy of deciding how to resolve make that policy decision.
And I would just say, this is true of, certainly state by state, we have different laws. I mean, so if you're someone who works, has employees in Indiana, they go with the federal minimum wage, which is $7.25 an hour. I mean, so, employers have to make those decisions all the time. And, there's all kinds of laws that are different in different states and different jurisdictions. So, this is nothing new, you know what I mean, for business and for workers, so.
I want to repeat a little bit more of what this gentleman in the back row said, because this session is being videotaped for whomever may want to click on it later on. And his comment was, for fairness and for his worker satisfaction, he finds it would be difficult to pay his employees who are doing the same work, although in different locations, different pay scale, and that there would be, understandably, resentment on the part of those who were being paid a lower wage. So again, that goes into what Wendy was saying. Those are some of the choices that employers have to make. Thank you for bringing that up.
So I'm confused with paid sick leave and paid time off. It's the same thing you were talking about.
Well, the question is whether paid sick leave and paid time off are the same. And not exactly is the answer. Paid sick leave is time that may only be used for sick time, as opposed to paid time off, which is a larger umbrella. It can also mean that an employee may take time off for vacation, but if the employee uses that time for vacation, then that time is not available when that employee is sick.
And I should add that the reason we made it paid sick days instead of paid time off, that I know, employers are kind of moving more towards, is that paid sick days is not a liability to employers if someone leaves. You don't have to reimburse them for that, but paid time off you would, because it works more like vacation pay.
So I guess my question is then, do I offer both, or am I?
You could do either.
Either or. And then, so if I pay for vacation time off, that's not the same as paid time off.
Okay, the question is, if I paid for paid time off, it's not the same as paid sick time. And the answer is, that's correct, it's not the same. So one of the most frequent questions that my department and I think Ray received when the ordinance first went into effect was from employees who said, well, my employer has always given X amount of paid time off in the form of vacation, and now they're calling it paid sick leave or whatever they're calling it, but it's still the same thing. Well, as long as that individual has the ability to take time off and be paid when they're sick, and accrues, it's the accrual, the earning or granting, the carryover, and the usage. So they can use that when they're sick, their family's sick, for all those reasons, then that's acceptable. An employer who has always granted time off for vacation or whatever and paid it, does not have to then give 5 more days of paid time off. The important part is meeting those 3 obligations that I spoke of earlier.
Yes, ma'am.
So for Wendy, you mentioned something about an $8.25 an hour. Who does qualify?
So that's the state minimum wage.
Could you repeat the question?
So she was asking what is $8.25 an hour. That is the state minimum wage. And pretty much every worker in the state of Illinois, there are some exceptions, like I mentioned, for employees with less than 4 employees, for businesses less than 4 employees. There's some exemptions, and there's other exemptions, except since the city ordinance was passed, we actually passed the Domestic Workers Bill of Rights, so domestic workers under state law also, not just under the city ordinance, it's 1 or more employees. Yeah, that's everybody. That's everybody in the state of Illinois, pretty much.
You said 4 employees or less. I hire at times up to 1,000 employees a day. Depends on the production. They work part-time, say 10 events a year.
Doesn't matter. You have to pay.
8 or 11? I always pay 11. I don't know if there's a minimum.
So it depends where they're doing the work, as we were
In
saying.
Chicago, mostly in Chicago.
Well, then you have to pay the city minimum wage, which is now $12 an hour.
Employee there and whatever.
It doesn't matter how many hours
Okay.
they work.
Okay.
Okay. I'll be quick because I want to share something, verify that I understand something, and then ask a question. What I'll share with I do HR and financial consulting for the food service industry, and I want to share with all of my business owners that I came from a few years ago from the DC, Washington DC agent area. So if you can imagine in your mind, working in DC, you're subject to 3 different taxing agencies because you've got Maryland, Virginia, and the District of Columbia. So I want to share with you all that there is hope. It's easy to get around. Just understand, and if you don't understand, ask for help from your CPA or your attorney before you expose yourself to any kind of litigation. My next verification, and I just want to understand that I understand, and all of mine is with the paid sick leave. A year can be determined by the employer. It doesn't have to be a calendar year. Is that correct?
So the question is, under the ordinance, can the year be determined by the employer, or does the year, is it determined by the calendar?
And the answer to that is that, yes, the employer may determine what the year is. So, for example, an employer may say the day of hire is the beginning of the year. And you can have 100 employees and have 100 different start dates and have 100 different years, and I don't know that your accountant will appreciate you.
Well, wait till you hear the second part of my question.
Or you may have a fiscal year from July 1 to June
Exactly.
30th.
Right,
There's no, that's perfectly legitimate.
sure.
But the same 3 obligations for paid sick leave qualify.
Got it. So the second part, which is the question and the unbelievable part of this. Have a client that's a food manufacturer here in Chicago, and what they decided to do, and another small piece of advice I'll give my fellow business owners, sometimes you have to determine the value of your time and the value of your time in record keeping. Sometimes if you're record keeping 50 cents here, 50 cents here, if you think about how much time that you're spending doing all this, sometimes it's actually cost you less money to pay everybody the same amount. But so I have a food manufacturer employer. They have 66 employees, so they're subject to the FMLA. And what they've decided to do, which is great, is on the 1st of July of this year, they pay every single one of their employees a week's pay. So if they do that every year going forward, does that relieve them from the obligation to let an employee accrue time off if that's what they choose?
Okay, so this is an interesting question. So the question is that a business has, think about this while I'm repeating the question.
It's so unbelievable.
Actually, guys, there's a reason I brought him, you know. So the question is, for a business that is obligated under the Family Medical Leave Act, that means it's a certain size. They have decided that at the beginning of their fiscal year, which is July 1 to June 30th, they have decided to pay each employee a week's wages. Does that, and the question then is, does that then relieve them of obligations under the minimum wage and paid sick leave ordinance?
So in answer to that question, an employer is certainly allowed to
Give a bonus.
give a bonus, or to grant the hours up front at one time. So all of the employees are granted 40 hours at the beginning of the fiscal year, for example. That's okay. The part that concerns me is that when the employee needs to take the time, that employee needs to be receiving the pay in their standard paycheck as they normally would for that time off. In other words, if they take a day off, the fiscal year has begun July 1st, and they take a day off in November, they've accrued the hours. They're not going to see a diminishment in pay during for that day off that they took. I would have to read the ordinance a little bit more carefully to be 100% sure about that, but that is certainly the goal of the ordinance.
Right, it would defeat the purpose of the ordinance. If
Right.
people didn't have access to paid sick days when they need them under the purposes of the
Okay,
ordinance.
and my response would be, I want you to look up at the slide that I put back up on the wall. The paid sick leave ordinance has 3 obligations that employers must meet.
Okay.
And the first is either grant the paid sick time, paid sick leave immediately at the beginning of the calendar or fiscal year. So it's or if it's granted, that's fine, or it's accrued through the year. That's the first. The second is the carryover. Okay, that an employee can carry over up to 1/2 of the of the unused paid sick leave except for FMLA eligible businesses, which means that the employee can carry over up to 40 hours for FMLA use. And third, the usage, so that I can use it if my kid's school is closed because of the swine flu, or I can use it if my workplace is closed because of a measles epidemic, or I can use it because my sister is a victim of domestic violence, or I can use it because I'm sick. So that bonus pay, which the business so generously wants to give, and I'd be happy to have it, wouldn't everybody here, does not fulfill the obligations for the employer.
The idea that you can't, I mean, for any of us, some of us are good budgeters, some of us aren't, but the idea that you're gonna take that $500 and put it in your savings account, and then when you have to take it out because you miss a pay. So I do understand. The answer to my question is no, it doesn't really.
So I want to piggyback on something I think Wendy said earlier. The ordinance terms this paid sick leave, and paid sick leave then is not, does not, the ordinance is very specific that if it's unused, if paid sick leave is not used, then the employee does not cash that out at any time. So if it's not used, great, it's not used. I mean, we in the city, for example, earn sick days. When we retire or move to a different job, we don't get paid for those days that we didn't take as paid sick. It's an insurance policy.
So if they lose it, what prevents use it or lose it? So what prevents employee, because you don't need certification for absence until they've gone 3 days, right?
Okay,
So obviously what's going to happen when people come to the end of the year, you better not have it all the same day, because you'll not have any employees, so the employees will take their unused sick leave.
But this is a policy that most employers who offer paid sick days now have. I mean, I never use up my paid sick days. I'm healthy. I haven't had to, I mean, that's just,
Yeah, but isn't that rolling over?
Okay, so let me
only a
just,
certain number roll over.
excuse me just a minute, for purposes of the tape. The question is, is this a use it or lose it situation? What happens then for the employer at the end of the year when half his workforce haven't used their paid sick time? And what happens when everybody on the week of December 20th then takes off the next week or so?
Well, first of all, there is some carryover. You can carry over up to half of the amount you've earned and haven't used. So there is some carryover.
So you're earning 52 hours a year.
40.
Well,
So you're earning 52, you can only carry over 20. So that's 32 hours. You're going to lose, right?
You can only accrue 40 hours in a year, 40 hours of sick time. I know that you
But
work
only
longer,
carry over.
and you can only use 40 hours.
and you can only use 40 hours in a year.
Yeah, but you're going to carry over. So if I don't use any for the 12 months, that would actually work out, okay, 40 hours. So
You get 20 hours to carry over.
you lose 20 hours.
Okay,
So why wouldn't an employee just have the flu for the next 3-4 days?
Okay, so again, that could happen in any business anyway, but the purpose of the carryover altogether was that in January, a person hasn't earned those 8 hours of sick time or 16 hours of sick time, but may get sick in January or February, or their children may get sick in January or February. So that those carryover hours are there for the person to use.
Also, that your scenario makes two assumptions. One, that every employee started the same day. because they accrue them at different rates and different times. So not everyone will, even if they're all working a full time, if they start at different times, they're not going to accrue at the same rate. They won't have the same number of hours at the end of the
Yeah, we
year.
assume you have long-term employees.
Sure, yeah, if you've done no hires.
Work more than a year with you.
If you've done no hires in that year, then all of your employees, yes, would be at the rate. And then it's also assuming that they're all using the same number of hours of sick days throughout that year, which seems reasonable, unlikely. Some people would use none of them, some people use all of them, and some of them would use some in between there. So I think that, I think in your hypothetical situation, that could be the case, but it seems practically speaking, kind of an unlikely scenario that all employees starting at the same time all use exactly the same number of hours and all were to take the same exact days off. I don't know, I've never heard of a situation like that at any company.
Okay, so we have a hard stop at 11 o'clock. Let's see how many more questions we can get through quickly. Remember, you actually had your hand up a while ago, so I'm going to call on you first.
So my question is, at my job, some workers work 6 days a week, 10 hours a day. If they miss one day, should they get paid 8 hours or 10 hours?
I'm sorry.
If they call in sick one day, are we obligated to pay them for just 8 hours for the 10 hours they regularly work?
Oh.
So the question is that the shifts at your job are 10-hour shifts. That's an interesting question.
I think that the employer would have that the ordinance allows the employer the flexibility to arrange it so that an employee can take up to 10 hours in a day if the employee wants to.
But you weren't asking about sick time. Were you asking about how much you have to pay them?
No, sick.
But did you ask whether they had to pay them for 8 hours or 10 hours if they take? Right, so you're saying it's up to the employee to decide how much they want to use.
Employee, not employer.
Right, that's what, Barb was saying earlier, that question about the 4 hours. So there's a minimum amount. You can't make someone take 8 hours. The minimum amount is 4 hours. But then once you kick in at 4, and let's say someone wants to use a full 8, then they can add 2. Let's say they want to add the 10. They want to use the full 10 hours. Then adding just 2 to 8 would be okay, right? Because you're not taking a minimum of 4. You're taking 10.
But if we choose 2, we can only pay them 8.
So
as an employer, as an
right, no,
employer.
I see the tension there, but I think that I think that the ordinance does not, and I'd have to look more carefully, and I'd encourage you to consult with your attorney to look very carefully at the language of the ordinance. I think that the ordinance is rather flexible. It sets the floors, but whether it's 8 or 10 hours that is taken, I think that either could be done. Let me try to get one.
Okay, so I recall the protest, the Fight for 15 and all of that. And for people who aren't really in the loop, it's like, okay, we kind of forgot about it, and now we got $12 an hour. So Melissa, you touched on it, how there were focus groups and action committees, and I just really wanted to know, how did it go from, the public outcry to this great change? Like, what was happening behind the scenes? Like, how does this ordinance, like, legislatively, how did it really happen?
You're talking about the minimum, so the question is about how we got the minimum wage, because you remembered there was a lot of protests.
Yeah, right, in terms of like aldermen and what organizations were involved.
Right. So and everyone here can certainly jump in on minimum wage, but similarly, as I talked about how the sick time ordinance that we introduced is not the sick time ordinance that was passed, it's similar with minimum wage, that I think it was Wendy who said, originally a lot of the activists were asking for a $15 minimum wage. And similarly, instead of just passing that, the city set up this task force. And if you want to go into discussions of how they wound up, the task force recommended, they recommend the 13, but it was supposed to be over 4 years, but it wound up, the ordinance was 13 over 5. But do you want to talk about how we didn't even get the 15 we wanted?
Well, that was probably the main discussion point in the task force, was how much.
Okay.
You know, and they did a lot of research. They looked at, you know, I mean, at that point, Seattle had gone to 15. You know, we're talking about 4 years ago already. So there's been a lot more cities and states that have passed $15 an hour since then. But, you know, it was relatively new then. And so it was sort of, you know, it was because they were trying to get to consensus. It was sort of a compromise decision on getting to the 13. So it was trying to take what, you know, workers were protesting about and to respond to that. And that's what happened.
And I think it's a broader discussion than that also, that as Wendy mentioned, that there were business organizations, Illinois business organizations representing different industries that were part of this conversation. So the concern of the city council wasn't just for the workers, but also the impact on businesses in Chicago. And there's a weighing of interests and concerns. And as Wendy said, there have been studies now that have shown the impact has not been as negative as was feared. And the conversations around minimum wage and around employee protections continue, not only nationally, and certainly in Illinois, but also here in Chicago. I think we'll take one more question and then hard stop.
Yeah, this is an easy one. Work experience programs. Are internships and paid internships equivalent to work experience programs?
So
Here's a question.
the question is about work experience programs and what gets covered there. The part of the slide that talked about work experience programs refers to the Illinois minimum wage law and one of the exclusions. If you have a copy of the rules, Rule 1.05 says employers that, an exclusion is employers licensed as employees, licensed as learners by the Illinois Department of Labor. So if that paperwork has been completed, that's what's included that's what's excluded. So if an internship, if the people in an internship and the employer has gotten these learners permits for these interns, then they would be, but not automatically just because they're called interns.
So you would need to get a permit, you're saying?
It's a state
License.
It's a state approved program, state approved programs. Okay. I actually, we do have to have a hard stop at 11. I want to thank everyone for coming, and you're certainly welcome to stay after. And for those of my colleagues who are not time bound, they're available to answer questions, and we hope this has been a good experience for everyone. Thank you very much.